Good morning. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case King v. Justice Party, 672 NE 2D 900, Illinois Appellate Court, 1st District, 4th Division, 1996. Third parties, third parties, third parties. That is a mantra we are reciting today and other days. This case involves the Justice Party, and if I'm not mistaken, this is not the same Justice Party that Rocky de la Fuente ran for later, as I read that party started in 2011, and this was in 1996. Also, I'd like to mention, here we need to consider the definition of third parties. When I looked up third parties before, one way I did that was looking through the records of secretaries of state. In Illinois, I found a lot of these organizations that were called party. There were tons of them. There were names like Citizens for a Better Palatine, Illinois, or Environmental Citizens Party. There were tons of these, and I never heard of most of them, so I'm not sure if they're what they are. If you're from Illinois, or if you have other knowledge, you are free to enlighten me. I'd love to find out. So we're going to assume this is a third party in the sense that we consider third parties. We're going to give this the benefit of the doubt. I'm not sure what those other groups are. Maybe they are third parties like we think of the Libertarian Party, the Constitution Party, Socialist Workers Party, the Communist Party. Or maybe there's some alliance that just calls themselves party. Maybe if the fact they call themselves party makes them a party. Maybe it does, maybe it doesn't. It confused me because I never heard of these, and I saw so many in Illinois. So I would love to learn about this. This case involved something I haven't quite seen so far, which is an election board supporting a third party. Yes. So let's read what happened and what the court decided. The record says, quote, on August 5th, 1996, the respondents of the Justice Party and its candidates are Eugene Pigcham, Janet Dennis, and Smith Williams, collectively referred to as candidates, filed a nomination petition with the Cook County Clerk so that the candidates' names would appear on the ballot for various Cook County offices to be voted upon at the general election on November 5th, 1996. On August 12th, 1996, the petitioners William C. King, William A. Brown, and Joe E. Jacobs filed objections to the petitions seeking to have the candidates' names removed from the ballot, end quote. It doesn't address the motivation of these people. Why did they object to the petition? Why? Are they being petty? What is driving them to do this? If they don't think third parties have a chance, why not just let the public decide? What is driving these people? The decision says, quote, the Cook County Officers Electoral Board issued a unanimous decision on September 12, 1996, overruling the objections, declaring the petition valid, and ordering the names of the candidates to be printed on the ballot for the November 5th election. On September 20th, 1996, the petitioners filed a petition for judicial review of the board's decision in the Circuit Court of Cook County. The Circuit Court issued an order on October 3rd, 1996, affirming the decision of the board and denying the petition for review. End quote. That's good, my friends. The Cook County Officers Electoral Board said you did the right thing by filing the petitions, you did it right, so we're going to keep it. But these people objected for some reason. Does anybody out there know these people? Does anybody out there know this case in greater detail? And you can let us know why they objected. I hope they didn't have good objections, because I don't like objecting to third parties getting on the ballot for petty reasons. this case hinges on the idea there was not perfect. They didn't produce the petitions perfectly. One of the issues is pagination. They say it started at 1 and went to 790, and then it skipped 791 and 92, but went to 793 to 4429. And they said there were some pages that didn't have any numbers. They did note the Justice Party got way more than the needed petitions, the signatures. They said the Justice Party was supposed to get 25,000 petitions, but they got about 100,000. Good job for them going above and beyond. I remember when I was running for office, the county clerk, if I'm not mistaken, said you need to have extra in case some of them are invalid. So that's good. Maybe that's what they were trying to do here by getting so many. If they have 100,000, they only need 25,000. That's a lot of buffer in there. Fortunately, this court is believing what the electoral board said. They believe that the electoral board had validity in asserting that the Justice Party here did do the right thing and got enough signatures, and the signatures are right. They said the Justice Party didn't do it perfectly. I don't know if anyone ever does, but they do say the Justice Party did enough. So therefore, they say the way the district court ruled was fine. The Justice Party should be on the ballot. Does anybody know how the Justice Party did in that election? Maybe they won. Who knows? For sure. Friends, we can celebrate this victory. We can rejoice. I haven't come across too many victories so far in looking at these ballot access cases, but here we have one. So props to the Justice Party for winning. Good job, friends. Good job. Long live third parties. Goodbye.